Valerie, if you would, please, can you call the roll?
Joni Manson. Here. Mike Kavler,
Here.
Tom Need,
Here.
and we're missing Virginia,
Virginia Lewis.
Virginia Lewis,
Sampson, and Brittany Hopper.
and Brittany.
Brittany may be here. She didn't tell me she wasn't coming.
Okay.
So we'll see. Okay, well, we are in session. And I saw our two guests, public members, went over and signed the sheet so that we want to make sure that we have a listing of attendance. And did we have anyone that has joined us on Zoom, Valerie, that you're aware
I
of?
did not see
Doesn't look like it.
anybody.
Oh, Mike's on check. Good. Thanks, Mike. Okay, well, we are on Zoom. The meeting is being recorded. For those of you who are here, if anyone does join us on Zoom, they basically will only have access to ask questions when they are given permission to do so. But they would have the opportunity to do that at some point during the course of the evening. We have two public comment sessions, one at the beginning, which we offer the opportunity because sometimes people come in and they have a question that they would like to ask, and we don't necessarily want to force them to sit through the entire meeting if it's something can be answered quickly. To just get that question of clarification at the end of the meeting. But the reason we have it at the end is that there may be things during the course of the meeting that there's going to be additional public comment and or questions about. Good evening, Scott. Scott Sanders, the director of Delaware County Regional Planning, has arrived. We'll get to working on our agenda in that regard, Scott, in just a few minutes. We do have Mike Cannon present as the director of zoning in Harlem Township, and our new assistant to zoning, Valerie Hamill, is on board with us again. Valerie was with us, what, 3 years ago about?
20 to 22.
Yeah, okay. The previous zoning assistant we had resigned unexpectedly. Fortunately for us, Valerie had given us an indication that she was interested in doing some additional work. And it so happened that because she made that comment, she was then contacted to see if she would be interested in coming back. And
Here
enough,
I am.
so, in that regard, we were fortunate that we were able to find someone quickly. All right, with that, I'll ask you gentlemen that are here as guests, Mario and
Scott Messer.
Scott Messer.
I'm an attorney. I live here in Harlem Township, 12767 Woodtown Road, down the road here. And I'm helping Mr. Capaccio with some zoning issues that he's having with his property. And we're here today just to ask a couple questions to kick off the process to just kind of understand where we
You might want to go from here.
That's correct.
All right, good.
So with that being said, Mariano has owned, it's at 12039 Center Village. It's the property that he owns. He's owned that property for approximately 5 years, maybe a little more. When he bought that property, it's zoned AR1. When he bought that property, the only thing that existed on the property was a storage structure. He needed more storage, so a couple of years ago, I believe in 2020 or thereabouts, he built an additional accessory structure on that property, storage building. Went through the process, obtained permits, all that. And since then, he's been storing some of his equipment in that new building. Just a brief history of where we are. There's no residence on the building. There's no single family home. There's never been a residence on the building or on the property. just the storage building and the extra storage building that he built a couple of years ago. Because he doesn't live there, and because it's not, a residence of his, it's not really an option to be running a, home occupation or an extended or limited occupation for, in business purposes. And so what we're trying to do is possibly look at changing the zoning, to a planned commercial and office district zone, which would allow him to rightfully operate his business on this.
So it's not agriculture then.
He does not use, it's a, I mean, he does storage of equipment for concrete,
Yeah,
whatever else. I don't know what other
I
equipment.
do for walls, storage panels,
So
What
he
is
has,
the size, the acreage of the property?
7 acres.
7 acres.
Mhm. And so, we've met with Mike. Mike sent a letter, to, Mariano, just kind of outlining the concern of, you know, a business operation in the AR1 district. And so, I think that's when I was contacted to just try to help out to see, think what Mariano really wants to do is be a good citizen of Harlan Township and make sure he's zoned properly and make sure he's aligned with the rules here. It never was his intent to, you know, do anything, contrary to the zoning. Like I said, when he bought the property, it already was being used for storage of equipment, and he built an additional, you know, pole barnish type facility a couple of years ago because he needed more storage.
Was there a, that was before Mike was hired.
It was, Matt was here.
Was there a zoning, permit provided for the new building?
Mhm.
Oh, there was.
Yeah, so that's kind of where we're in a place where it's like, okay, I mean, he was kind of, as a matter of fact, when he contacted me, he'd actually like to have additional storage on the property, if he could, build another building, just because he could use the extra storage. And that's why we're thinking, well, you know, maybe the better option is just to, rather than try to sit and be grandfathered or something like that, if he wants to add more storage or do anything on the premises, that's why we thought maybe changing to a commercial, a PCD would be better.
Okay.
But maybe not, maybe, you know, maybe you guys have some thoughts on that. Yeah, like I said, Mike has, you know, rightfully just asked some questions about the legitimacy of what he's using the property for, and we don't want to just leave that unaddressed.
Okay, good job. I'm sorry, go ahead. I was gonna.
Do you have a map of the property? Is this, do you know
Give me-
if
do you
if
have
it's
the
located within
address?
the
You can bring it up.
Harlem
Yeah,
Village area?
12039 Center
Oh,
Village.
you know where, well, it's almost 2 houses down or 2 or 3 houses down from the school. You know where the dump truck place is
Oh,
on Deal?
yeah,
Catty corner to that,
okay,
across the
It's-
road, on the north side of the road. So it's about
north side of
a quarter
Centerville.
mile east of Miller Paul.
It's well outside of the village area itself.
Okay, so it's east of Miller Paul
Oh,
and,
sorry, west, not east.
okay, so it's west of Miller Paul.
Yeah, west.
Okay, and east of Harlem then.
Yes.
Okay. I was gonna see if I could quickly bring that up.
Feels like it's
Mhm.
just
Could
west
bring it
of
up there.
Hartmanville, yeah, right?
Yes.
Let's see. Here,
County
What did-
auditor.
There's a auditor site. You get some lost light about it.
um, Not opening.
If you could sign in,
Oh, there
excuse
it
me,
is.
sign in at the registry at the table back on the corner, please. Thank you.
I I think based on the description that you've given, Mike, that a PCD probably is the better option.
Yes. That. Yes, I agree.
You're
You're asking my opinion, yeah.
I mean, unless he was gonna establish a residence.
Yes.
Try to go down the extended way, but he does not want to establish residency out. With like a
I
single
can-
family home.
Bring it up on that, then we can see it on that screen.
You talking about on here?
Yeah, by just going to the general web.
Do that while it's already on Zoom.
Yeah, I don't know that we can do that. I think it'll take your Zoom down. Just go grab my computer.
Which server is it on?
You actually have an internet on?
I don't know, I gotta find that. Usually just links hooks up right away. Here's one. I should have brought my Apple because I'm not that familiar enough. I don't use this thing for much of anything except having to communicate with township. It's cumbersome with it. Where's the settings on this thing? There's no policy.
Yeah.
Here. See if we even hooked up.
Well, maybe Scott knows how to do it.
Wi-Fi.
No, you can't pull that.
No.
Well, you got the share screen.
No, we're connected.
You get it?
No, it just doesn't seem, it's, you got it there. Okay, good. That was much easier.
Yeah. Just gonna grab it and bring it up. Here's the mouse. This is the property right here. Here's Harlem, here's the school. This is the property.
All right, this is the property. Which one is it again, Mike? This one.
Yes.
Okay, so this is, we can't see it on the map right now. the way this is set up, so, but this is Center Village Road up here.
No.
No,
Let me
No.
shrink this down for you, like you're. Ooh, not too much. Damn, Christmas.
Is it north or south of Center Village?
Now my computer's gonna go whack. It's north of Center Village.
Oh, it's north of Center.
Yeah,
It is,
that's what it looks like.
it's right there, Mike. This is Harlem, this is Center Village.
Okay, so this is the school?
Yeah,
Yeah, it's right across.
All right, so it's north of Center Village, and it's next door to the dump. Okay, you're talking about the
the
dump.
dump truck
which
place is right here. This is the dump truck place.
Oh, right here. It's on the south side.
Yeah.
All right, then Garibrand's over here.
Yeah, this is Garibrand. I think you probably bought that property off Garibrand, didn't you? No?
You said, say
Did
again?
you buy it from Garibrand? Who did you?
No,
buy the
I
property?
bought it from, his name is Scott.
Okay.
Anderson.
The guy, yeah.
I
the
got a
buyer,
better
he
idea. I
probably,
didn't know where it was either. Okay.
So,
All right, so what's adjacent to it are some other 5 acre parcels or 5 acre plus parcels.
Everything to the east is FR one. All the parcels along Harlem.
And this is Miller Paul over here.
Whatever the school is on.
Yeah,
Yeah.
that's Miller Paul. That's the school.
Yeah, so all of
Oh,
those
Miller Paul.
parcels are on Miller Paul. These are all FR one.
Yeah, these, yeah, they're on Miller Paul. These parcels are. These down here are on.
how long is it for?
Yeah, Center Village. And then this,
I gotta be
that's what it
something
is. So, they back up to it. That's right. It's hard to remember exactly what it is. Okay.
Scott's got it up here for Rich.
Thank you.
I don't know if you can see that, but this is the
Yeah.
property right there.
Okay. And now we've got a good understanding. How many buildings are on the property already?
There's two. The
Two.
one that was existing when he bought the property and one that he added.
Okay. Well, for commercial operation in that area, there wouldn't be any other option besides PCD. Hey, I mean, if you had a home on the property, potentially
Right.
it could be a
Yeah.
extended home occupation.
He doesn't want it. He doesn't want to do that.
But you don't want to build a home. You don't want to live there.
No.
We have a house.
Well, then a PCD, if in terms of looking at potential zoning, that would be the only option to consider.
And we're not looking at, I mean, he's not having customers there or he's not actively running a business in the sense of like all day long. He's literally just storing his equipment there.
Yeah, we leave in the morning, they come back.
So it's not really operating like a retail or a commercial business with customers.
Right, but it is similar to others that we have that are like landscaping companies.
Yes, and we've got,
And the PCD specifically calls out an acceptable use. It's just
Mhm.
for storage.
and once the PCD gets approved, then that becomes the zoning specifically for that property, whatever is identified as the uses.
In your
the
plan.
Structures, that's fixed then. That's what
Yes.
is operational.
That's why as a part of the PCD, I think what he wanted to do was go ahead and propose a third building now so that we can just get it all approved.
Well, that's what you should do.
Yes, we would just propose the storage building now, what it looks like, and that way you have the three buildings on the property and anything that would want to be added in terms of screening or restrictions or any kind of special items could be all included in the plan for the PCD.
There's the option and what we would recommend, or, and we do recommend for people who are considering the PCD. Is to utilize the preliminary meeting process whereby you would develop a concept plan, if you will.
Mhm.
What it is that you are proposing on the property. And we schedule a meeting. It's not a hearing, but it's a meeting to discuss informally what it is that you are proposing to do. And then you would get specific feedback regarding those ideas. You would get feedback and you would preliminary talk about where the building is going to be located. Preliminary sketching of ideas about how you would screen, etc. All those kinds of things as part of a plan by looking at that. That would be a preliminary, but like I said, you wouldn't go to the expense of necessarily having professionals do the drawings or expense of doing extensive work in that regard. That's the preliminary part. Now, once you would get an idea from there, then you could potentially go forward. And if you submit an application, then it becomes you make a decision at that point based on the feedback that you get. And members of the public will be able to participate as well. And if you make a decision at that point, whether you want to go ahead and move forward with actually going to the expense of submitting an application.
That's when you need the proper architectural renderings and stuff like that.
Right. So that's where the additional professional expenses would come in. They don't have, it doesn't have to be done for these preliminary discussions, I thought.
Great.
And a PCD is
I'm sorry, ask again.
PCD.
Planned commercial district.
PCD, yeah, planned commercial development.
Thank you.
So we call Mike or who would we contact to
You
set
would
up? the
work with
preliminary
Mike.
meeting?
Mike can give you a sample
Mhm.
of the PCDs, one of the PCDs or more that has been approved in the township. Maybe Brown down here on 605. Brown Landscaping. Which one do you think might be a good one to suggest to Mike that he pull out for?
Yeah.
Well, it's Charter Oaks and,
Charter Oaks, that's the one, I'm sorry, I used the wrong one.
Yeah, we do have that one for Brown. It's also,
Yeah,
it was our first. And we really,
yeah,
really worked with them a lot on that.
so, those would be, because it doesn't, those would be similar, as Jody pointed out, to the nature of what it is that you want to do.
Right.
So my understanding is that the buildings now are used strictly for storage, equipment and supplies.
That's right, right?
Yeah, storage, supply and trucks.
You don't do any fabrication there
No.
and no equipment repairs. It's just in and out, morning and evening.
But I have a compressor fixed on tires. Yeah.
Okay, okay, but no, you're not pouring concrete on site.
No,
Okay,
We strongly encourage you to talk with your neighboring properties so that they aren't surprised and then they come and object during your hearing.
And by talking with them, hopefully we can explain to them what it is and get them on board with you.
just knock on the door. Yes.
Yeah, look them up well, it's hard to look them up online anymore. But yeah, you can,
you'll find them on the auditors.
the auditor's website will give you addresses if you want to send a letter.
Yeah.
It's just like we brought that up. If you bring it up online, then you can see the neighboring properties, and by clicking on each one of them, using the GIS, it'll give you the name and address of each property.
Or knock on their doors.
Yeah, just
And-
knock on their door. If there's, unless it's just a vacant lot, then you,
Then you can't.
I didn't pay that much attention. If there's structures on the property, doesn't necessarily mean it's a house. You'd have to know by going there. All right, so the way to proceed would be you would use the form to request a preliminary meeting.
Great.
And that's available online, I think. So you could fill that out and then we would end up scheduling you for a longer extensive time. And you would have a concept plan in terms of what it is that you're thinking you would like to propose.
Fantastic.
Okay,
Thank you
All right.
for your time.
you're welcome. Thanks, Mike, for getting your laptop.
I'll get that from you.
If this is the only one I'm bringing, I guess I'm gonna have to practice using it. Nice. All right, okay, well, we have a couple of other new people that have arrived. I'm not sure, members of the public, are you here as observers or do you have a question?
I have a question.
What's your question?
So we recently have acquired a property at 5540 Miller Hall Road. And we are attempting to split the lot. And we've been kind of going back and forth trying to get everything in order to be able to create, make the lot split happen. Because my wife and I here are wanting to build. It's a 21-acre property. And there's just certain hoops that we gotta jump through to make it happen, get it approved. And we have most of our stuff together, but before we get to the official, the meeting where we are able to submit in order for it to be considered, we just wanted to make sure that we had everything in order and kind of show you what we had and see. If we
Okay, well.
Mike, could we ask first, could you introduce yourself, please?
Yeah.
I was just gonna ask him that. And
Yeah.
Thank you. If
My
you-
name is Jefferson Stern. This is my wife, Caitlin.
Hi.
They.
Hi, and your address again?
5540 Miller Hall Road.
Okay, have you met with Mike Cannon, the
Yeah,
director?
well, we spoke a couple times on the phone now at this point. Nice to officially meet you.
Yeah,
Hi.
unfortunately, I've spoken to so many people.
Yeah, I don't,
Yeah.
I definitely don't expect you to remember me. It's been just a few calls here and
What are
there.
you trying to do?
So we're trying to split the lot, about a 5-acre portion towards the front of the lot here. This is.
Got it.
The lot, yeah, so.
I know what it is, yeah.
Oh.
If it's gonna be a full 5-acre split, you don't need to rezone it.
I think they're talking about, you own 5 acres approximately now, and you want
We-
to split that?
We
No,
own, it's,
21.
my mother is the one who purchased the property, Rebecca Stern. It is a 21-acre property.
Now, are you just gonna split off 5 acres?
We just wanted to split off 5, yeah, at the
You
front.
don't need to come to us to do that.
I don't believe
You can split a 5 acre lot off. I don't think you have the frontage.
Yeah, there was that
Ah.
ran into issues with the frontage, and so then it was,
And I think I put some time into that and we decided, I think it was you had to be, I don't remember the exact one, but it had to be either 2 and less than 3 or 3 and less than 4. I can't remember which one
yeah.
gave you enough frontage to do that. They will not be able to split 5 acres off of that.
Okay,
We weren't wholly set on it being 5 acres. We were just under the impression initially that that was like how the easiest way to move forward would be. And then we ran into issues like Mike just said, where
you're,
we were like, okay, well, it doesn't need to be 5 acres, but we just were told that would be the easiest way.
it would have been if you had enough frontage.
Yeah, if we had the frontage.
But if it doesn't, then you may just want to change your zoning from AR1 to FR1.
I think that might be exactly what we are trying to do at this point.
Yeah, that is what I told her you need to do. Come,
Yeah.
get your zoning changed, because this is where you have to do that. You gotta get changed to FR, and then you would proceed with that, because they don't really approve the lot splits. They
Yeah,
just
so-
approve the change of your zoning, the lot splits, guys.
I guess that is what I'm here for then.
Is to
because I
change
think we're
the
trying to
zoning.
change the zoning in order to make this happen.
Well, in order to submit a request, you need to follow the procedures that are specified then in the they're online
Yep.
procedures for making a change in the zoning map. And it would be, in this case, you'll have to get my best advice to you, if you want to, is to utilize a professional that can help you with it. It'd be simpler than trying to do it yourself. But if you have the time to do it, fine, go ahead and do it in that manner, just to make sure that you've got all of the information that you need when you submit the application, because you have to decide, you have to have you'll have to have a survey or whatever piece of property it is that you.
We already
I believe we have that done. I believe we're pretty much there.
I think we're
I've
at
got
like
the
the
list.
tail end of what steps are needed. I think we came here for clarification of what it is that you do versus what is the next step that we have to do. So
Well,
you're saying that we need to go online and submit a rezoning?
Yes, you would use the application form and follow all the steps that are there in the procedures. They're specified online.
yeah.
Okay,
and
so
then-
we-
think they've done all that.
Yeah, we've
Okay.
done all this. It's just, we basically think we have everything we need.
Okay,
And then the next step would be, from my understanding, to submit that at.
You would
meeting,
submit the
right?
application at one of our regular meetings. We would not accept an application tonight.
Yeah, I know, and I'm
You would
clear on
bring it
that.
in.
We're just here basically to make sure that we have, and if we could get clarification from you guys that we do have everything in order, so that when we do show up to the meeting, we aren't stumped where it's like, oh, we forgot something, we misread it, and now.
There's no way you're gonna get that answered until
Okay,
you bring it in.
yeah, all right.
We can't tell you that you've got everything in order.
So
before we
the
bring it in.
the application that you filled out, is it for the whole 21 acres? Change the zoning for the whole 21 acres?
I could not give you a full confident answer on that because a lot of this has been handled by my mother as well as me, so I'm not sure if we're rezoning the entire 21 or if we're just rezoning whatever portion we would be splitting off. Or how that would work, but
But you can't split off
So it all needs. to be
certain amount
changed.
of,
Like the full 21
acreage.
acres needs to be rezoned as,
You don't necessarily have to rezone all 21 acres. But you will have to have a survey that shows specifically boundaries of the acreage that you want to rezone.
and you
Yeah,
can't
I
leave, you
believe
can't
that's
leave a
this
portion
right here.
that's not going to be able to do anything on it. That the portion you leave still has to have frontage and whatever else is necessary so that your mother isn't left in the lurch for, a piece of property she can't do anything with.
yeah, I think,
At the very minimum, there'd have to be 60 foot left.
Yeah,
yeah. I think-
which when she called me and we sat, I talked to Brad, we went through a lot of this, so I can get all that information together for you. And we have been going back and forth on the email, but that's been a couple months ago, I think, that we stopped that, but maybe not so long. But, yeah. Did you guys get online and get the checklist and everything else, and you follow the checklist,
Yeah.
and you feel confident that you've got all that stuff?
We've got the joiner list here, got the survey done, we've got I just haven't, the only thing I haven't done is make the copies, because it says you need, 13 copies. Yeah, I just haven't gone to make the copies, because I figured once we came in here, asked our questions, things seemed okay, I would go make those copies, bring it into the meeting.
If you haven't filled out the application yet, then that would be your first step to go through the application and then use the checklist, go through the procedures and make sure that you've got all the steps met. And you have to make that decision. We can't make it for you. Mike is not permitted to do that for you either under directive of the county attorney, county prosecutor's office. Then you bring the application in, you submit it, and we will potentially schedule it then. If we accept the application, we will move forward by scheduling a hearing.
Okay, when we bring that in and give it to you guys?
First opportunity for you to bring in an application and submit it will be February the 5th. That's our next regular meeting. So it'll be the first meeting of every month.
Okay,
So there's one meeting a month where we accept applications.
and when we come to the meeting, do we need to schedule anything beforehand to make sure that we're able to get in, or is it sort of we walk in
Open
kind of like we
house.
did today?
So that, you don't have to schedule yourself for that, because that is simply bringing the application in and we
Yeah.
will.
And the
We
5th
will
is a
accept it.
public meeting for us anyway.
Okay.
And at that time, we will schedule when the hearing will be, which is likely to be our first meeting in March.
That's most likely when we would schedule it.
Okay, that makes sense. And then. Is there any? One final question that my mom wanted to make sure I asked is there anything in the paperwork that states our intentions or reasons why we want to do the variance? And if so, is that in writing? Or a public statement at the meeting?
Variance?
No, is that just the wording you?
Yes, that's the wording she had
Yeah,
texted to me, yeah.
Yeah, I don't know where the word variance came up, because you don't need variance on it.
Yeah, what you're looking for is a rezoning. And it needs to be clear to us and clear on the survey how much of the 21 acres you want to rezone. If you're only rezoning 2 or 3 acres, it's got to clearly show that on the survey.
Okay.
And it
And
has, the minimum has to be a minimum of 2 net acres.
Okay.
I mean, it can be more than that,
Mhm.
obviously. But she potentially could rezone the whole thing if that's what she would choose to do, but it's not necessarily advisable, but that's up to her to make the decision.
Understood.
And there's a cost to that.
Yeah, the cost would be more to do it. It probably would result in the taxes also going up because that means that more houses could be built on that property.
All right.
No, not without
They're
the
only gonna
front.
get this one split out of the
Yeah.
property, or.
Oh, yeah.
That's definitely the only intention would be the one.
Yeah,
But
you're,
this-
yeah, you don't have the great frontage. A lot of property, but no great frontage.
Yeah.
But there's no access for a common access drive going back.
Property that backs up to the conservatory to Duncan Run. You go through, but it's off of Miller Hall. It's a big property that shoots back in there, and you can see it from
You wanna see the,
Jim's house.
No, we do not want to spend time dealing with that. I mean, that's a matter of you making a decision about whether you want to move forward and exactly what acreage you want to rezone. That's another reason why it would probably be best to consult with a professional planner.
Okay.
And there are several of them out there. They've done it before. They can give you very specific advice. They've gone through the zoning process before. They will be able to give you specific advice about that as well.
Understood, thank you.
And I'll show you guys where on the website you get all those forms. I can do that.
okay,
Okay.
yeah, that'd be great, thank you.
All right, thank you. I hope
Thank you for
that
your
at
time.
least is a little bit helpful. And then
Yeah.
if you do want to submit the application, February the 5th, or what is it, March the 4th?
Mhm.
Because we have a leap day, yeah,
Mhm.
March the 4th.
All right. Yeah, I think we'll definitely be in here February 5th is the goal.
Yeah,
Okay.
yeah,
Okay,
thank you.
you're welcome. Good night.
Good night.
You guys have a wonderful.
Okay.
All right, well, Scott, we're ready to get to the reason that you're here. And we only have three of us here tonight, as you can see. I did distribute the changes that you made in 7 and 8 electronically to everybody, so they had that. I put on there, and you had mentioned that with regard to the application forms that you had run those off so you would have them. I would like to address that, not that we're going to revise the forms here tonight, but just to decide what we think is the way to approach this. My thinking has been that maybe we need 2 application forms. We need one for the overlay districts. And then we need one for all the straight districts, which would include some planned districts. PCD, PRD, PID. But for the overlay districts, we created the PRCD application 2 years ago because we didn't have one for that, and we didn't want it to be that overlay district to be confused that we were in fact changing the zoning.
Mhm.
We're pulling the overlay district down onto the property, which makes it then not subject to referendum. That was what we were trying to avoid. So that's why I'm kind of inclined to think that maybe that's the way to do it. Scott, you have an opinion about that?
Well, I can see why you would have 2. Because one is a rezoning and amends well, they both changed the zone map, but one is considered an amendment to the zoning
That's it, yeah.
resolution essentially. and they Just changed the map, but, and then the other one is application of an existing overlay to a piece of property. I mean, the only difference is the title of the page. Because, I mean, it seems to me you're asking for the same information no matter what. But your current, like your AR1 to FR1, you have the addresses on one sheet,
Right.
which obviously bleeds over into other sheets if there's more than 6
Mhm.
people. And then this one just has it on the back, and I just feel like it would be more simple to just have one for an actual rezoning and then another one for the overlays, and maybe list what those districts. You'd be surprised when we see these forms, because every township does forms differently. And some, well, I mean, people don't know what their they don't know what their current zoning district is. It's all over a farm or lot, they won't put
Well, what we
what it is.
we've gotten some discussion with DG that possibly we could create, like a drop-down menu. So that when they could fill it out online, and then they would the menu would drop down and they'd pick what zoning they were changing it to. But for the overlay district, but we have now so many options for an overlay.
Mhm.
We almost have to have a way to identify them. Well, which overlay is it that they're applying for?
Right, but I mean, that's, part of that is up to them to know what they're trying to do. I mean, they should be able to do that research on their own if they're
Right.
serious about it. And I just think rather than try to have, well, you're not gonna have a form. You wouldn't have a form for every combination. You would just have a form for every district that you're gonna go to. But at that point, I don't know why you would do multiple overlays and multiple. Just seems easier to just have a standard thing, get the information you need on the cover. And then the critical thing is, what is your zoning now? And what are you applying to go to?
Yeah, so
Or what overlay are you applying?
what overlay? So you're thinking, do I understand you're saying that you think that it is best to look at having one for changing zoning as we normally think of it, and then a second form that would just be utilized where they're going to apply to pull down an overlay district onto their property. So it'd be two forms, one for
Yeah.
the overlays, one for changing zone.
And what you put behind that, I mean, it depends on whether you want, this is sort of like a checklist, right? This is the
The
one.
instructions.
Yeah, that PRCD, yeah, that's
Follow
what it
the
looks like.
guidelines, and it just has the requirements. Which that could be a separate sheet for each one, where you just copy down.
Yeah, I like Scott's suggestion that we have basically the same form for both, looking for the same information and just a different heading. One is applying for rezoning and the other is applying for applying the overlay district.
But it's not one form, it's two forms.
Two forms, different headings, but everything below the heading, essentially, we're looking for the same information.
Yes, I don't disagree with that at all. I think that's what I had in mind too.
And it would be nice if we could set it up online so people could, pull down, drop down menus and just select what fits. And they can't wander around and kind of mess things up.
And people will do it paper wise too, so.
Yeah.
And most drop downs, if you just print it off without dropping down, you can still write it.
Mhm.
I thought this was an odd one online that it's your plan district meeting request. I mean, is that the application for rezoning?
No,
No,
That's just,
that's for the overlay.
no, this is the meeting request. Like we were talking with
Preliminary
those,
meeting?
well,
what does it
Oh,
say preliminary?
Can't bring it up again.
yeah, but it says preliminary subdivision / plan district meeting.
That's what we were talking to these guys about. If they go for a PCD, they can bring us their concepts about the whole thing without having to do the full architectural plans and landscaping plans and everything. And we will meet with them and go through things so that when they do fill out the actual application form,
Yeah,
They're-
that might need a little bit better clarification in the header as well. Would use the word informal, or I would recommend using the word informal in there somewhere, that you're requesting informal session. I mean, calling it a meeting is fine, but it seemed almost like because you're asking for what's in the development plan, so it looks like a rezone.
That's your
requesting here. It seemed odd to me.
That's not an application form, if you're saying that's would be considered, we actually refer to it as an application.
no, I don't think we do.
No, it says request for preliminary subdivision.
Yeah, that's
It's
this,
okay the way it's worded. It's just-
this is the one that you have, right, Scott? It's headed request for preliminary subdivision / plan, yeah. And that was set up. And then that was included because these would be the things that when that was designed, not that they would do a checklist with this, but these would be the things that they would consider then when they would bring it in. These were the things we want to talk to you. You want to talk to us about.
Yeah.
Because those are the requirements in the plan, but I know since we've revised we haven't done the PCD revision, I don't know whether even if this is all going to be applicable, is it? I didn't go through to check it against the PRD that once we revised it.
I don't know, I didn't look at that.
Well, we haven't looked at it yet.
PRD we have.
But chances are, everything that's here is still in as a requirement in terms of their development plan, because that's essentially what this is a listing of the elements that were in the development plan.
Right.
So, so what we're talking about then, 3 forms. One form, application for amendment of this zoning map. Second form, requesting all the same basic information for the to apply for an overlay district, and then continue to use this if they want to do a preliminary meeting. What do you see on this one? Did you see in terms of changes that you thought would be needed to this, that you've identified it?
Is that the meeting?
The request for preliminary subdivision?
Yeah, well, you just said something about making sure that you call it something like informal.
And I will tell you, I don't know if you're using. So we're going through the Berlin Township. and We used Pete Griggs' group before, Don Rogers Johnson Griggs. No,
The township has in the past. I don't think they're using them now.
I know that there are attorneys there are attorneys that want to be sure that any informal conversations include no more than two people.
Yeah, can't have a majority.
And it kind of worries me if you're gonna schedule a meeting, because you're gonna have three, right?
No,
That's the way we've
the
done
meeting,
it.
we've actually had a full board, and it's been a public meeting. And it's been advertised.
Yeah. Sure, I'm not sure that lessens the concerns that legal folks have with having a meeting that's not you're not really considering what they're bringing, you're chatting about.
Well, we do look at what they bring us. They just don't have to bring us the expensive stuff.
Yeah. And that's fine. Just have to be careful what you say, I don't know.
Oh, yes. Yes, nothing that is said at the meetings, and I think it's on there somewhere.
Yeah.
Is to be taken.
Information sheet about the, said. Nothing that's said can be considered to be binding. so to
Binding,
speak.
yeah.
Yeah. Right, I just thought I would mention.
But still, it's one of the reasons why we got out of the preliminary meeting business entirely. Start with.
Yeah, and then we've been getting pretty much crap at some of the application hearings.
Our disclaimer, basically,
Didn't tell me that I needed to do it, that's our.
it's not on that form, Scott, but we do have another sheet that we distribute, and one of the statements in there is the zoning commission will make no decisions regarding the proposed development during a preliminary meeting. And none should be inferred from comments made during the preliminary meeting. Maybe as we would revise that form, we would need to put that information on the form itself.
Couldn't hurt.
No. Well, I think to some extent, these forms that we're talking about do need to become a priority, that we need to get the new ones in place. Because we have the potential for so many overlay districts potentially to come down the road now that they're all in effect. I don't know how quickly anybody's going to apply, but if we don't have something in place, and the other piece to that, which I just thought of today, as I was looking at the schedule of zoning fees, there's never been a fee set for the 4 new overlay districts. How much do we charge them for that? It's not on here.
It's got a limit.
So it's up to the trustees to do whatever they want.
I think, I mean, there are other things that are missing, I think, from the fee schedule, that as we do the applications, we should make sure that they're listed properly.
Yeah,
And that we're agreed on the fees and then have the trustees sign off on that.
because there wasn't any recommendation that came from strategic planning and fees for it.
Yeah.
We have the PRCD fee, which is separate, and then there's a separate fee for a PUD.
But the PRCD is an overlay district, and you could say extend that, I don't know what the fee is, but extend that to all the other overlay districts.
Oh, yeah, I don't disagree with you. Yeah, right now, though, that doesn't say that.
But it seems like if you have I mean, I guess somebody could argue that well, it's not a rezoning, so your rezoning fees don't count, but you could say, well, we. $1,200 base fee and then 165 per acre. And just say, well, that's what we do with everything.
Yeah,
I don't know if you want to give. I mean, that's not to discuss now, I guess.
and maybe we,
Is it less than a rezoning or is it the same as a rezoning?
do we, do we need to be concerned about calling it an application? Maybe we should change it. Change the title of it.
No, it's still an application to apply the overlay district.
Where they're applying to apply the overlay.
Yeah, and to your point, Scott, I think if we're going through a development plan, whether it's for a straight district or an overlay district, there's still a development plan that we have to review and approve. That takes as much time. So I don't think the fees are out of line in terms of the amount of time that gets put into it. Question is whether it's a rezoning, no, but it's still, does it meet the development standards in the overlay district?
Right, it was, it's like your PRCD, it has a different base fee, but the acreage fee is the same. 165.
Mhm.
And when you say straight, you mean still with a.
Or a planned or
The narrow one, FR1. Probably the same. And there's not really a development plan, but it's probably the same fee.
Actually, I think our regular rezoning fee is different.
Rezoning fee for amending the zoning map.
Yeah.
Yeah.
It's $1,200 plus 165 per acre.
Okay, and what was the PRCD?
It's 2,000 for that,
Yeah, that one is more.
plus $165
acre.
per acre on the acreage not reserved for open space.
Yeah.
So basically, for the pulling down the overlay, it is a little bit, there is a small reduction there. It's a percentage reduction. But if you got 100 acres.
Yeah.
it's 50% open space. It's a
Yeah.
big discount.
It's a few $1,000s, yeah. Well, Scott, in terms of the, let's focus specifically just for a minute on the application for a member of the township zoning law. Is that title okay from your perspective, or should that be changed? This would be for all the straight zonings, none of the overlays.
Well, my revised code always refers to it as you're amending the zoning resolution. Even though it feels like you're just changing the map. I don't know if that makes a difference, but that's just. I mean, yes, it is an amendment to the zoning map. And I guess unless it's a plan district, you're not really adopting new language. To change something from AR1 to FR1, really changing the resolution itself, except that the map is part of the resolution. It's probably a, what's that called, a distinction without a difference.
I mean, I don't know how long this form's been used in the township, but it's been around for a very long time.
Right.
We had talked about making some changes. And I've got some notes on that. But we never, I don't have a copy of a draft that was prepared where these changes were included.
No.
Just the handwritten copy that I have here. So I can give this to Valerie so she could revise it for us with changes that we had. I think we discussed this way back in November.
I think it was before then.
They might have been before that.
Yeah.
I found it in my file from November.
Okay.
It's not that long.
Right, so I would,
Well, it showed that we had it on the agenda for discussion in October.
okay,
So maybe that's when we actually talked about it, and then I ended up with it in the file, in the November file.
I mean, so just get back to the title, it could be application for zoning amendment. And then in parentheses. Non-planned districts. And then the other could be,
Or non-overlay districts. Not planned. I thought we were doing,
not planned or overlay districts.
because even the planned districts, I thought we were gonna treat the same as straight rezoning. That's what I took Mike's early
Yeah.
suggestion to be. That the difference is between what's a rezoning subject to referendum.
Sure. I mean, it depends on whether you want to, and maybe you want to keep the top sheet simple and not put. That you need to include a development plan. Because everybody needs the legal description, everybody needs the property owners,
Right.
even the overlays need property
mhm.
adjacent. Yeah, I was just, yeah,
But to continue what you were saying is, to call it an amendment to the zoning.
just the zoning amendment.
Zoning
Application
amendment.
for, change in zoning, is that the way you said it?
Amendment to zoning.
I'm just saying application for a zoning. For a zoning that.
That's what I wrote down.
I'm trying to get away from referencing the map or the resolution in that way. It's just. You're just amending the zoning and that captures both. And then in parentheses. Not. Not for overlay, not. I didn't think it had enough about this. So I'm just kind of going off. Like that. I don't want to use the word straight district because that's really just something that we call it. We don't really.
Right.
That's not a good definition.
It's not, and that language wouldn't appear anywhere.
It could just say in parentheses, does not apply to overlay application. And then the other form would say application for. Use of an overlay.
Now, we typically use slang, we just say pull down, but I don't know, is that the technical? What it's called in the ORC or?
I'm sure it doesn't use that. Specifically.
Yeah. Then you could avoid using the word apply twice. Application for pulling down an overlay district, but not very.
Application for the application of the overlay.
Well, it could always be an application for utilizing overlay district.
Out of that.
Well, obviously, whenever we do a draft, it'll still be that, so then we'll go forward from there.
It's a good start.
Yeah, try to get the process started, yes, exactly. And then for the PRCD form that we have, there's a lot on that we would get rid of. The way that it's currently set up, I mean. Because it's just not applicable. Any longer.
I would say. On this, the oldest form, it says total acreage to be rezoned. That language seems to be missing here. On the PRC, total acreage to be rezoned. I think it was just a copy and paste. You definitely want to know how much acreage is being rezoned. Then you still, you're still gonna code them with a number and a resolution and the date.
Mhm.
So they
Yeah.
don't need that thought,
Yeah, this,
Mhm.
except for that.
yeah, all of this narrative that's in here would be taken out of the existing application for planned residential conservation. Well, it's just gonna be set up using the same basic information that we want. And this was all copied from the original one. So we do the same thing for the overlay, but it won't be just for PRCD. And you'll need those information for the property legal description for the property owners. Now, for the overlay, there will be a requirement for the development fund. That, I hear what you were saying before about, for the plan districts, there will be a need at some point for the development plan
Right.
for those, but does it come in with the application? Or do we have
Yes,
a?
it gets attached, so that we have everything
So we
for a
would have,
hearing.
maybe we deal with that by having a statement that goes to says something to the effect of, for any planned districts, a development plan needs to be attached.
I think you would handle that with you would always have a second sheet for every district. And that's where you would list the things that are in the development.
Yes,
Or maybe an asterisk on the main form that says for plan district C, sheet 2 for requirements.
well, we had, the way that we had the procedures, when we described the procedures before, we separated it that way. That, application for a change in zoning on the property. And it went down through, 8. And then number 9 stated an application for a change in zoning to a planned district shall contain plan development drawings, and then it goes on and gives all the specifics. But we wouldn't necessarily need to do that here, I don't think. I think we just need to make reference to whatever the requirements are in the individual plan district, because we modified that when you did the PRD.
Yeah, yeah.
So you think it would continue to be useful to have a document like we have here with the, where we describe for the applicant everything that they need to include in their application?
Only if you do a direct copy and paste, because you don't want to be. You don't want to end up with something on your form that's not what's in the code.
Right.
And be told, well, you didn't tell me that I had to do this doesn't say traffic study and you're telling me to do. So. As long as this is a direct copy.
Well, what I was thinking of for the plan districts would be that we wouldn't necessarily identify what the specific requirements are, but we would refer to
Oh,
the zoning code,
see article.
the article,
Well,
yeah.
yeah,
Mhm.
that was what I was gonna say.
And then that way, we don't have to worry about whether we reproduced it all, because we're just saying they need to refer to that article.
Yeah.
To then be sure that all those elements are included.
Yeah, that takes all this. Off the form.
Yeah, it takes it all off, so we're just
I haven't
asking
seen
for
that
the,
many forms, but I haven't seen that much detail on a form before, because you always might forget to make an update someday.
Mhm.
yeah,
When you change the code, then you have to remember to change the form. Yeah, it'd be much better to just say. See section 18. The article 18 for requirements for. Everything.
Yeah.
Okay. I made that number up, that's not really.
I know you did.
It's
Um,
13. For 23.
So, not necessarily a question for you, Scott, but the members who are here, how do we proceed with this? You need to have a commitment in terms of developing the forms. Can we split up that role?
Except that you really want the two forms to be as similar as possible. I
Well-
suppose we could split it up and then when we get back together, just take the best parts of each one.
Or if we come to an agreement on the first one, the application for the change in zoning, that
Use that.
becomes the basic form.
Yeah.
And then the basic information that's on there automatically transfers over to the other one. We don't change that portion of it.
So the newest version of the application for rezoning is online already? Is that the one that DG worked on, or didn't she get time to do that?
She never got it up there. Now, what's online is the same as what we've always been using.
Okay.
It hasn't been changed. So. I'll give this to, let me give this to Valerie and ask Valerie if she would retype this. So that it would have more than just the handwritten notes on it. And I don't know, Valerie, whether you can get this all on one page or not. That's our goal, trying to do it.
I'm not sure that the existing one is in a Word document that you can just go in and make changes.
Yeah, it wasn't in a Word document before. Okay, well, let's do that. And that'll be the first step we'll make in terms of revisions. We'll focus on this one first. We'll get that one so everybody can look at. And then Scott, you'll see it again and we won't spend this much time again with you talking about it, but you can give us some input on it. Okay. Now with the Articles 7 and 8. Scott, how do you want to go through those?
I don't have a preference. I didn't really turn up that much. And that, all this I had done a long time ago, but then when we really started, we wrote it hard to.
Mhm.
So then I just revisited it again. And simplified a little bit because we changed that limited home occupation. Which I
I like it if we don't have to change much.
yeah, that's not a bad thing.
It's not a
Sometimes you
bad
feel like, well, did you really look through?
So as you went through, you identified those elements that either needed to be changed to bring us up to date to be current with the Ohio Revised Code, or potentially to help simplify some of the wording and eliminate some of the wording. And also to bring it to make it consistent with what we changed in the development standards.
Right.
Okay. So on page 1 of Article 7, you've only added a couple of minor changes.
And that's just. It was weird that it said agricultural beekeeping.
Mhm.
I think it's supposed to be agricultural purposes.
Mhm.
And there's even, I don't know, I just noticed in another township. An attorney had recommended, they've added the name. They've added the word algae culture to the definition, the ORC of that agriculture, but it doesn't really affect us here.
Do we,
Is that what the ORC 51921 is? That's all the definitions?
Yeah.
Could be. Okay, so if they change ORC 51921, then we'll still be okay if we just refer to.
And you're saying it's permitted, you're not You're not trying to prohibit something that's gonna be changed. At some
Mhm.
point.
But with the adding that subject to the provisions at the end, does that apply to the whole paragraph or just to the writing statements?
That's a good point. Let me move that up under agricultural purposes. For agricultural uses, subject to the provisions of ORC, including beekeeping.
Yeah,
Is that a better way to?
Mhm.
I think so.
Can we,
Because we wanted it to be applicable to the whole thing.
can we shorten it even more and just say agricultural purposes subject to provisions of ORC, period, and not,
Not list
and
anything?
not enumerate anything? So as ORC changes, it just covers whatever it defines.
I kind of like having a little bit of structure here to give people some ideas about the breadth of it.
But then you're saying this is the breadth and not something else.
No, you're saying agricultural uses subject to the provisions in ORC 519-21, including but not limited to. I think that's the wording we use in
Yeah.
a lot of other places, including but not limited
We
to.
could put that in it that way. And then it kind of get. Tom's looking at maybe eliminating some words.
As much as possible,
Yeah,
making it as short as we can. And I would, so that's just my suggestion, is just make it the definition subject to the ORC, and we don't have to follow it and update it or give anybody an idea what's in it or not in it. You want to know, go and look it up. If you don't know. And because even for us, is a dog kennel considered an agricultural use? I would have to go back to the ORC and see what it says,
well, it's not listed here.
but it probably should be.
It's funny you had mentioned that because that came up in Berlin's legal review because they have that as a conditional use
Yeah, that's where it is for us too.
and. Jen just said. She didn't say that's a problem. She just said. Please realize that the argument could be made that that's an agricultural use. But
It's made.
it's probably safe to keep it as a conditional and just see. Until somebody, I mean, that's a hard argument. to make.
It was the
That's
argument was
really-
made here and it flew. And without going back, I think at that point, we were advised by a former prosecuting attorney who's now a judge that it was an agricultural use and we shouldn't even be ruling on it.
Yeah, well, those are the same people who support puppy mills, so I don't really agree with any of them.
But if it's in the law that a dog kennel is an agricultural use, we have no control over it.
I don't know whether
I bet
there
there's
have been
many
any
kinds of kennels.
specifics.
Yeah.
One is the guy that has a farm and has dogs out on, then they can't, well, what? There's a place on 23 that clearly is like a business because people board their dogs there over the weekend. And I'm sure that's what country kennels do too as well, but it's just different. I don't know where you draw that line between what becomes a business, because you have just as many cars coming and going as you do in a not as
Okay.
busy as some places.
I'm never gonna agree that kennels are agricultural uses. I don't care if
If it's in the ORC.
it's in the ORC, that's fine, but I don't have to bring it out and put it in front of people.
To tell them.
So we're not saying anything, we're
No.
just saying if it's in the ORC, if that's the definition, we go with the definition, because we don't have any authority not to. That, I guess that's. So, I don't wanna.
We're gonna.
I don't even know if all of these things we have listed are listed in ORC 519 anymore.
I don't know, the language that's there has been there for years and years. so
Yeah.
Who knows?
I'll put a note to look. I mean, assuming that we're gonna leave it in, I'll put a note to look up agricultural uses or purposes and just make sure it's consistent.
And we're gonna change the word purposes to uses.
Probably. I'll look at how it's listed.
And you're gonna make those changes that we're talking about, you'll take care of updating it as we go along, right?
You'll double check me, but I'll try to.
agriculture uses, and then we're moving that phrase subject to the provisions of right after that, instead of having it at the end.
Yep.
And then are we going to leave it in as including but not limited to?
He's gonna look those up.
Yeah, but whether we don't have to make that decision, I guess, right now, but for now, we can, as a final decision, but for now, we can leave it in that way. Then we have all five people who will make a decision on whether we take it out altogether or not. Okay. Going on to the next page, now, the changes over here on limited home occupation. In accordance with section 2117, because we moved this to the development standards. Is that the only change on that page? That's the only one I can see. Right,
Yes.
It's a huge change.
yeah, and then the next page. Again, we're making references to the development standards. Instead of sections within this document. Seven oh four.
I don't see anything on that page.
Beg your pardon?
I don't see anything on that
No.
page.
I know, thank you, right, I didn't either. 705. It's got changed, under D. Just as defined or as established by the Delaware County Health District, change that to Delaware Public Health District. Not more than one manufactured home, et cetera. I think you changed it because that's the official title, is that right, Scott?
Yeah, I took that out completely from FR1 because we took that paragraph out somewhere else. Because if you're gonna rezone to FR1, you're probably gonna develop it as a single lot.
Single-family
You
home.
don't want,
Yeah, you don't want
somebody saying,
manufactured.
well, oh, they're my full-time labor.
Yeah. Even though
left
they
it
may
in
be,
here.
they may be able to do agriculture, you don't necessarily want a full-time labor.
Right. Well,
That would then have to, well, no, not for agriculture, I guess.
that's a phrase that's been in everybody's code for a long time. I just don't know if anybody
Thought about it.
uses it.
Well, but well, of course, under AR, we would want to leave it.
Mhm.
I mean, it's still conditional, right? So you
Right.
still.
And then next page, this is where we get to the boarding kennels. That's the only change there, again, just public, as opposed to county. And 705, 707, I'm sorry, page, and then the development standards, a lot area. You're suggesting we drop the word net here.
I don't remember if that was way back that I took that out. I mean, there's a larger discussion, I guess, to have on FR1, just. I know you all like the net.
Well,
Do you define net here?
but in some instances where we may have a large utility going, power transmission line going through a 5-acre lot, may take up an acre and a half
Easily.
of the property. We in fact had one of those
Harlem Road.
down here
Yeah.
on Harlem Road. And they ended up not having enough acreage.
They could not do a
They could
split.
not split because they didn't have enough acreage. When it was net. If it were gross, they would, obviously they had 5 acres. But they did not have 5 net acres.
God, you shouldn't put a house underneath those high tension power lines anyway.
No, they should not.
I'm sure you're.
Not that you can't allowed to either, yeah.
Well,
I was just wondering if you're suggesting we delete it, what was the rationale?
well, I would say, do we define what net is? I mean, I know we've talked about that before.
It's all over the place.
I think we did add it to our definitions though in Article 4. Didn't we add that?
We were talking about not just road right of ways, but recorded utility easements, recorded easements of all kinds.
Well, in FR1, you'd say no parcel of land in this lot area, no parcel of land, which has an area of less than 2 net acres excluding all road easements or right of ways in this district shall be used for residential purposes. So you tell what net is there, but A1, you just, AR1, you just throw the word net in there, and I'm just
Yeah.
worried that doesn't.
Yeah. And I don't even think in the definition section, at least it wasn't clear. There was no consistency throughout the resolution on what we meant by net acreage. Sometimes it was road right of ways, period. Sometimes it included easements of some sorts of or another. And I think that, you know, if we get into a discussion, I think that that's where I think we need to settle on what is included and excluded. For one thing, you can say, in terms of road rights of way, they're not taxed. They're not included in the taxable acreage on the auditor's website.
We have a large definition for net developable acre
It's something different.
acreage in our.
Yeah,
That's,
But-
that's different.
Well, you look under lot, comma, minimum net acre.
yeah, that's exactly right, page 407.
Mhm.
That's any right of ways.
And the only thing that's defined here is exclusive of any rights of way, right of ways, I think it's,
Rights of way. Rights of way.
yeah, we got the S in the wrong place in the document.
Yeah.
Mhm.
So if we follow our own definition,
That's what I'm saying. There's no consistency in the document at all. And I think more than anything, we need to reach an agreement on what we're trying to define as excluded in net acreage.
The problem with being as broad as you want to be under this definition is that when you get into a PRD and they put all these lots down the road, and every other one, they'll usually put a little 5-foot easement between to carry drainage from the yard to the street or from the street to the yard. And then you're getting into a lot of easements that sometimes aren't even used.
Yeah, but all those plan districts have their own development standards and don't have to follow these.
Well, sure. Well, they wouldn't have to follow a standard in FR1 or AR1, but you're in the, you know, you say the area. You say a lot is the area. And that's why in your definition, it just says right of ways. Because when you create a new lot, you typically will take the right of way out, and so that isn't it.
right,
My concern has always been, because I'm kind of on the end of people bring like these people, which I know that parcel, I've either talked to an consultant about that.
Oh, the one on the
The
21
big
acres,
acre.
21 acres.
Or I've talked to them about it. But they come in and they, you know, they got their zoning and they got their approval and all that, and then the county engineer says, well, we're gonna take another 10 feet strip. And that reduces their size and that. I mean, that's the bad example, because that usually goes through and they figure that out. It's the odd little easement that nobody knows about. I mean, at what point does an easement count? I mean, does a cable? Now, everybody's got a cable easement going across the back of their yard. Does that count?
Is it recorded?
Um,
I mean, I would say to the point where we're trying to get to. At 5 acres, if you take this 21 acres and you say, I want to split off 5 acres, you don't even come to us. You just take it to the county engineer. And they split off 5 gross acres, no questions asked. And it totally screws up our zoning. Because now it's a non-conforming lot and they don't care. They've been told about it, not their problem. Zoning is not their problem.
You're talking about one that has a big power line going across it, or what?
No power lines, just, they want to split off 5 acres, they split off 5.000 acres. And the county engineer signs off on it, it's done. And now we have an approved non-conforming lot. As far as the township is concerned, it's non-conforming. This is not 5 net acres, because they're gonna have road frontage. Right, and they don't care.
Well, it depends if their survey goes to the center line, which usually they do, but.
Yeah. But I mean, so we've seen a lot of cases where, we get non-conforming lots that have just been approved by the county. Now you can say,
Well, don't say county engineer. All they have to do is go file something with map room. Well, it's the county engineer's map room, but nobody reviews it. So.
Yeah, and
That's,
that's
there's the
absolutely
rub.
true. I verified that by calling the
Yeah.
engineer's
No,
office.
we all know. that.
No one reviews it.
'Cause
So-
they're exempt in the revised code.
so
nobody-
should we bring the township into line with, at least on 5 acre parcels,
By dropping it.
5 acre parcel, it's a 5 acre parcel. Net gross, just 5 acres. I'm just making a point here.
The last time that I looked, which has now been several years ago, there were only there were 3 other townships besides us that applied, used the word net on 5 acres. And that's I'm not sure what's happened since then, because that was several years ago. There may not be anyone left but us.
There's
now.
only,
Do you
like,
know?
only Berkshire starts with 5 acres to begin. with. So there's no point in anybody else. There may be. Maybe another one. That's really all. Well, Trenton, yeah, so Trenton.
Yeah, that's right.
Berkshire,
Trenton
start with
was,
5
Trenton was
acres.
one of them, I
So
remember.
there's no reason for anybody else to even mention.
Mhm.
The net, because they're not gonna mention 5, there's no. There's no reason that they mention 5 acres to begin with, because they all started. To 1.95.
So do you think we should drop the word net in the 5 acres?
Well, he did.
Well, I just marked it.
Yeah, when we go down to the FR zoning though, it's a different situation where you're looking at least we were looking at. Is there enough ground for on-site septic and a backup system and, and then you take away, power lines and road frontage and drainage easements. No, maybe not. And the health department will say, we'll approve anything you bring us. We'll find some way to approve.
Well,
So,
for
yeah.
now, then, I think in terms of the discussion on lot area for 7, we leave it the way Scott has it written. Or he's got it crossed out. I mean, that was not just accidental cross out. You were deliberately thinking we should get rid of it.
I wasn't saying should, I just knew that that would generate a conversation, so I wanted.
Oh, okay.
Which is good that we're having.
And it
So,
did, it did.
I mean, I have heard from a surveyor that. That somebody in a meeting, goes back a couple of years, but that somebody said, I mean, similar to what you just said, we've got all sorts of non-conforming 5 acre lots out there. Which maybe you don't want. To make a big deal about.
Well,
I don't know, I think she interpreted it.
if
Incorrectly when she heard it, but.
we probably have said it in one of our meetings before, because it's not a new concept.
And non-conforming is still legal, especially if it happened because of some reason that you all didn't cause, it just was
Well,
a road easement that ate into a.
but they happen now, even though it's in the document, because like you just described, they go to the map room, they get it approved. And it's not, the surveyor didn't do it for 5 net acres, he just did it for 5 acres.
Right.
So,
Yeah, they do 5.001 just to give themselves some wiggle.
A little
room,
bit of
not to
wiggle room.
allow for some right of way.
The next time
That's-
somebody
that's
does it,
basically the width of the pencil lines, you know.
all right,
So
So-
I guess what would
I mean,
what would
there's
help me
better-
decide if there's, if the section of the ORC that defines agricultural, and I believe it's a 5 acre lot, becomes, there's a change in zoning on a 5 acre lot, where if it's agricultural, we just have no control over it anymore. If it's less than 5 acres, I think there's still some restrictions, zoning restrictions. What is that? Is that 5 gross acres? 5 net acres, 5 acres period, and nobody's asked. And I guess to eliminate conflicts, we just follow the ORC. That whatever they say for 5 acres, we'll have, or we should follow. Maybe. But I don't know. I'll have to look and see if I can find that in the ORC.
I don't think it uses a descriptor, gross or net or whatever, it just says 5 acres.
Yeah, I would imagine, yeah, the ag section would just say,
I don't know that for
Lot.
certain, but I
Right.
think that's the way it's worded.
And I guess it doesn't really bother me at the 5 acre level. It does bother me at the 2 acre
Yeah.
level.
I agree. I think makes a big difference there.
Yeah.
Potentially makes a big difference. All right,
So you succeeded. We had
okay,
conversation.
well, and we're taking it out. Just.
we're leaving it the way that you have it stated here,
Okay.
yeah. The cross out.
Do you know anything about the second sentence, where that came from?
Now, I don't know where that came from.
I mean, it's been in there, it almost opens you up for other uses, but. Well, as long as you're not using it for. I don't know. If somebody wants to go to the BZA and ask for something that's for them to do, not for you to open the door here, I think, and say. Oh, you may want another use, but you need to go to the BZA and ask for it. You know what I mean?
Yeah.
I don't know that we've got any uses that are identified as as a permitted use. That specifies,
Why would you be using another? article?
size.
You'd leave it AR. One, but you go to another article, and figure out what size you wanted it to be in. It just seems like. Language that may be 50 years old and we don't know where. it
Yeah.
came from.
Yeah.
I'm totally agreed. Take it out.
I don't see, yeah, I don't see any, I can't think of a reason for it either. So I'm fine with your deleting it.
Yeah.
The lot frontage. You didn't see any need for any changes there. And then going on to the next page, 708. Building setbacks. You added some language.
Well, it sounds like. Did I add that?
Yeah, is that sounds more like goes along with FR. I think we did.
Highlighted your existing language, which. If you're in a flag lot. And you have to have 50 feet from all sides.
And
if
I
it's
know-
not a flag lot, you can be. You can just do 15 feet. It just seemed odd that if you had a flag lot, you were required to have much. Larger side and rear setbacks than if you didn't have a flag lot.
And I know the zoning inspector really questions that. Been an issue for him. And
So
if
it
he,
should be more consistent. Just.
he would say they should be the same. Why are they any different? And I couldn't give him a reasonable answer.
And I can give him the answer, which I've given to him.
Which
That's
is?
what Dave Andrian wanted. It was the zoning inspector at the time. It got added at David Andrian's request.
Or we gotta,
Because David Andrian complained about not being able to determine which was front, rear, or side.
That was it, yeah. Because the way houses were situated on these flag lots, is sometimes it really couldn't tell which direction was a front.
I make them 50, why not keep them at 25, which is what their sides would be anyway? I mean,
Yeah.
Why punish the flag lot?
I know, I agree. I don't see why it has to be 50.
You don't even. I mean, the neighbor is impacted, but the zoning inspector's not even gonna. See it unless they bring it in for. Once the main house gets built. So I
Well,
mean, the red, everything red would be. Yeah, deleted if you wanted to be more. Fair, and that way the same. The same applies. I mean, you're always
the
with
rear
yard,
yard,
wherever the street
rear
is,
yard
that's your.
setback, the rear yard setback is even bigger for the principal dwelling, should be located. Can't be located closer than 50 feet to the rear line.
Well,
I'm
and
sorry, it says 80 here.
80.
That's more than the 50 in one direction.
right, and this, it does say it's not applicable to flag lots. That rear yard setback, that 80-foot.
Right, it does. That's my question there in terms of why does it need, if we change it to make it a minimum of 25 on all sides, and it's gonna be 25 on the rear as well.
Mhm.
Is that what we want?
Mm. Yeah, you're getting really close to a lot of neighbors there.
Well, what's the rear? You know.
Yeah, and if it's, the building is set on an angle, then, you know, the front side might be different from the side, then the back side is from the side.
Yeah,
So just giving the same number for all directions, I think was the idea there.
that was why he wanted it set that way. We take out all the red. Including not applicable to the flag lots, that means then that it's up to the zoning inspector to decide what is the front, rear, and side. And that's what David Andrew wanted to get rid of.
And I would say it's up to the homeowner to decide how they want to define front, rear, and side. Not up to the zoning inspector. If their lot drawing shows, here's the house site, here's the front door, and here are my distances to the property boundaries.
Yeah, actually, the property owner is the one who would do it and with their surveyor, when they identify where their building's gonna be located, they lay it out.
And if we say it's got to be 25 feet to in all directions, that's one thing. If we say it's got to have one of them, it's got to be 80. Which one do you want to make 80? It shouldn't be up to me.
It's the rear. So what's the rear of your house?
Well, opposite the front door, by the garage, or whatever, they orient the house. They say, this is the rear. Here's my 80 feet. I've got 80 feet in one direction. It's okay with me.
The current zoning inspector doesn't seem to have an issue with taking out all the red that
I agree.
is here.
Yeah.
If he doesn't, why should we?
I mean, well, another way to look at it is, you get your frontage. When the lot opens up. Once you reach that width,
Right,
you're allowed to go down to a strip, but once you reach the width, then you go 50 more feet before you get the front of the house. So you already have. Everybody's code.
that's
that
determining the
table,
quote front, so to speak.
But you don't have to face your. I mean, that's one way to look at it. You don't have to face your house that way, but that's still where you're gonna get your 50 feet of frontage or 50 front setback. Then your sides. Our side, if you choose to point your house toward your neighbor. You can't say, well, gosh, I can't believe they're only 25 feet away. Or 25 plus 25. I don't know. It seems like setbacks might be separate from how you decide to point your house. Or it may encourage you to point your house and.
So, that building setback on E. The language there would have to be changed. Based on what you just described,
I
Scott.
think your front, when you're in a flag lot, I think your front is already defined by that, by what I just read.
Like where the flag comes in.
So it's basically 50 feet. And if it's gradual like this, then once it hits the width, then that's the 50 feet. So it's gonna look bigger, but that's rare. Everybody just makes them mostly square.
So, but the building setback on paragraph E, that's referring to the front. If you take that out, without any reference to a distance there, setback distance, what would it be? Because if you go to 2110, it's gonna vary in terms of building setback depending upon the code.
Well, what you would make E be your front setback. Then you would reference 2110, because like the first sentence would be just like it is.
Yeah, so change the word on E from building to front.
Yes.
And does that make sense to everybody?
Or front yard setback. You got side yard setbacks, rear yard setbacks. And setback is either one word or two, right?
And
Well, that's true. We consistent with the language. You say front yard.
it should be one word. I think it's more likely seen as one. And then that second, you don't really need that second sentence at all in red because it's already referenced, but if you just wanted to be clear, you could say, in the case of flag lots, the main building of a flag lot shall have a front yard setback of 50 feet.
Would that be here or better in section 2110?
Well, 2110 is odd.
From the road right away. Yeah, because if
Yeah.
you look at 2110, you've got very,
Yeah, this from the center line of the existing
Center.
roadway.
well, they may be 1,000 feet from the center line of the road.
But we could still,
Because of the-
yeah, we could still, in the case of flag lots, we could still, I mean, you
Yeah,
can,
that's what Scott, I think, was suggesting.
but to put it in that,
I think that's why that was added at some point in the long ago, because once you got to the flag lot, then all those road frontage setbacks didn't apply anymore. And now you're like, well, now I'm way back here. I can be 2 feet off the front.
Right.
Right.
And so that's why they made it.
Yeah.
And should it be 50 feet there?
That seems to be pretty typical.
Yeah.
Other places.
So,
Yeah, in regular AR1, for a regular lot, it's 130 feet on class A roads, 90 feet on class B and C roads. So,
but the nature of flag lot, it already pushes you away from the
right,
road.
right, so that's why it's down to 50.
and
And are you likely to have a flag lot that's less than 70, with a flag less than 70 feet or whatever the difference would be between, 110 and
130 and 90, 40
No,
feet.
because you would think you'd have a lot in front of you, so that would have to meet those setbacks.
Mhm.
you would think. Yeah. So you're already going more than the
we're gonna have
setback
80
distance.
feet, the one in front of you,
Mhm.
because that's gonna be their backyard setback.
It seems like it would be rare that you would get somebody pushed up so close to the road on a flag lot that this would make a difference. Again, in terms of simplifying things and I'd be good just taking it out.
For E? Well, I don't think. we can
I
take
don't,
it out.
I don't think so.
I think
So you
it's
still want
something
50 feet back from wherever the
Yeah.
flag.
From
ends.
where, how do you describe that again, Scott?
It's under B. I mean, I can repeat it. And I don't think it's redundant because I don't think it's that obvious to people when they see
Oh, yeah.
why it's under frontage. I'm not sure, because that helps define where your frontage is measured.
Mhm.
How do,
I
can
just think
we,
it needs to clarify that in the case of a flag lot, the front yard setback is 50 feet. From the point at which the flag,
50 feet from the point at which,
Yeah,
yeah,
yeah, what you said, yeah.
and you can reword it that way then, if you would.
Just grab what you need from B.
At which it reaches 60. All right, good. And then we're taking out the not applicable. And we've answered your question.
Okay.
And rear is still okay at 80. And
I
it's
think-
probably enough that it.
That's,
Yeah,
I think we leave it that way, and this will also be run by Mike, because he's the one that's gotta enforce it, and it got changed to what we had, and that we're changing it again at the request of the zoning inspector. And now we've got a request from the new zoning inspector that didn't like the 50 feet all the way around. All right, so going on, we're up to page 709, which is blank. I think we finished Article 7.
Yeah. I mean, that section kind of ends roughly, but I think that was. That's the way it.
Great. Now, the revisions we're talking about, Valerie, Scott's gonna be making those, so. You know, all we do is kind of, minutes, try to kind of document what we're suggesting.
And I think Joni can confirm this for me, but I think L on page 708. There are no landscaping standards to speak of in the resolution, so kind of sending people on a wild goose chase.
Well, we're gonna, when we get to that section of the standards, we're gonna revise it.
yeah.
We'll put some in there.
Will we?
Why not?
I don't know that you're gonna be. I think it was probably general because it's hard to tell somebody on. They are one lot, they have to follow something.
Yeah.
Yeah.
I mean, the only standard I would know is under construction, they have to.
Well, I mean, we do have stuff in our standards about water impoundment and stuff. There's 2107 is called landscaping.
It probably just talks about erosion.
Proper ground cover, yeah. So,
Do you want me to reference that section and then when we work on it, we can.
that'd probably be easiest. 2107,
Good with that.
Okay, going forward on page 802.
he's got a note on page 801 there.
Oh. Yeah, well, that has,
I'm just.
we've been talking about that already, so I
Okay,
thought. Oh, well, we never reached a decision about, we decided that we take it out of 5 acres. So what do we want to include when it comes to net acres? Here, and Scott's pointing out, because we say excluding all easements and rights of way. It should be rights of way, right?
Yeah, and I've always used the phrasing recorded easements, so at least. You know where you have to go look. And if it's not recorded. It's not effective, it's not ineffective. That's how I would look at it. And again, because you're looking at the issue of septic. And are we gonna have farm residential and once sewers come in? Or is that gonna flip over to another article?
Well,
you're still gonna have some, because you probably are not gonna have every 2 acre lot being transferred to,
well, the 2 acre lots that are there will continue to close.
yeah, and most of them are not going to try to split anything, because they won't have the frontage.
They won't have the front, and they can't use the overlay district because they don't have 25 acres.
Right.
They need a minimum of 25. So it's not gonna, you're not gonna have these small 5 acre lots all of a sudden, or these 2 acre lots going to, oh, I'm gonna split it in half again.
No,
I don't think so.
Well, the only places where it would become, I think, applicable then would be somebody's got. Well, let's just say that they've got 10 acres. And with 10 acres, what are their options? Potentially, they might try to opt in this direction. So. Out of 10 acres, how many lots can they get? If it's, 2 net acres requirement, they should be able to get 4.
Before, they'd have to have 2 up on the road and 2 further in, right? On a common access drive, you can't have more than, I mean, theoretically, technically 3, but 2 more up by the road. Right? So yeah, you could have a common access drive and 4 homes. And you rezoned it to FR, but they would all be on sanitary sewers, presumably at that point.
Possibly, yes.
Yeah.
Well. In the south of Center Village Road becomes an option.
Yeah, and so then
At the plan right now.
you
If
say,
they stay FR1. If they stay FR1, do 2 acre, but then do a caveat.
but on
We don't
sanitary,
have another option.
right now, there isn't
Yeah. We don't have another option other than,
nothing.
all right, that's it.
That's it.
Whether we want to change that is something,
Yeah.
We
I
just,
don't want to think, I don't want us to start working on that
no,
now.
we just changed the R2s to just the existing
Right.
lots.
So on this, if they're connected to sanitary sewers, then the net acreage is not an issue anymore, because we're not concerned about, do they have enough space? If it's north of the sewer shed and maybe they don't have sewer connections, sanitary sewer connections for another 10 or 20 years, then are we saying, yeah, we still have the same rationale? We don't want to push the envelope.
I don't think we want to change it right now.
So right now, you think you want to leave it excluding all easements? But
Recorded,
insert the word recorded.
recorded easements.
Yeah.
And rights of way.
That makes it discernible, definable. If you can't find that the easement's been recorded, then it doesn't have to be considered.
And then we can go through, I think I did once, but we can do it again. I just did a search on the word easement in the resolution to see how inconsistent the definitions were for, maybe I was looking for the word net and came up with, it's never the same, and I would think we'd want to standardize something if we're going to use net.
Well, that means that maybe what we need to do is modify the definition.
And modify the definition for sure.
But any place that's used in the document, it should also be consistent.
You know how I feel about consistency.
Always the same.
Okay,
And on D, you're gonna change it to whatever you
I'd
changed
make you
7.
attach the other language. I'm gonna still say and also following restriction.
yeah. So
The idea
that,
was that in AR1, there weren't this many
Restrictions.
restrictions.
Mhm.
right,
Limited home occupation got moved again.
now the limited home occupation, we are deleting because well, reference to section 2117, because that's what we're proposing.
Yep.
It's before the trustees.
Yep.
Now, they're holding a hearing, if in case anyone did, Tom, you didn't know, it's on the 14th, is when they're holding a hearing on that. Valentine's Day.
Okay.
I wasn't at the meeting. Joni went to the trustee meeting and that's when they said it. Okay, on page 803. There's no changes except for continuation from the expanded home occupation. Page 804. Scott didn't have any changes. Scott? We got that no equipment processor. Does that belong in here now?
Which one?
Number 8 on page 804.
Because I could refer back to the. Where we moved all those others, right?
Mm.
Vibrations and everything.
I'm just wondering, yeah, because we created that. What is it, 16?
Yeah, and hazardous, I'll just write that.
Yeah, that's what I was asking about. Okay, so that's 2116. And then. moving on. Yeah, you took out C, you told us earlier, on the manufactured home.
Yeah, and that whole. Residential facility thing. Is different now than what it used to be. They renamed them all at one point, to the bottom of that page.
No.
So I mean, it's unusual to see those. Because they are facilities. They'd be hard to do on a septic field anyway, so.
928.
2-minute warning.
What's that?
It was a time warning.
Oh, okay. Oh, good.
I keep looking up there, but that clock is slow by a minute or two. And we have 2 minutes. We hit 9:30.
I think your changes to the residential facilities are good.
Yeah, you take out the definition there and you just say.
Yeah.
Article 4, and then in Article 4, you add that. The definition, which just refers you to the ORC. I mean,
Right.
and it's rarely gonna come up, but it's one of those things that's supposed to be in your residential districts.
Yeah, and there's no reason for us to not reference it that way. That's good.
So we don't have residential facilities in our Article 4 yet. Is that correct?
I still have a definition.
Yep. Yep.
So that will be a revision in Article 4 then.
Mhm.
And on 806, for the agriculture sales, we've got the reference identified as to. Rather than having them to have it all spelled out there. And then some of the language.
As far as I can tell, the only difference there was. Under permitted uses, you have, it's one of those things you have to allow. But not with permanent structures.
Right.
But then if you're gonna do it, you're gonna do a permanent structure for that use. Then you can. Require a conditional. Just make it.
Yeah. Okay. Didn't make any changes on 807, some of the pages I can get through it quickly.
Mhm.
Page 808.
Yeah, we already talked about that. So I feel like what I have in parentheses was just my notes. The line above it, I think we could probably mark out because we're not anticipating other uses in FR1.
Sorry, I missed where you're. Are we page 808?
Yeah.
Mhm.
Oh, I'm concerned. Okay.
All other uses in district shall have one, and in that line, you just delete it. And you didn't strike it out, but
I just marked it for discussion somehow.
Right. but it.
Fine.
We've agreed earlier to delete it.
Okay.
So. Page 809.
So here again, just under A, 806A. Here it says excluding all road easements. And rights of way or right, so again, we're saying. It's not the road easement, it's the. Recorded
recorded.
easement,
Recorded easements,
All recorded easements.
and that way that'll be consistent.
yeah, and rights. And rights of way.
Thank you, Tom. Yeah, that is what it should say. And rights of way.
That's easy enough to find.
Okay. 9:30. You want to go ahead and finish the last 2 or 3 pages or?
Yeah,
I'm not saying
it's
it.
only a page and a half
It's really
left.
just to get G and that
Yeah,
exactly the way AR one is, except instead of 50 all the way around, it's 25. All the way around. And flag lots are still treated differently.
Yeah.
But now we're in smaller lots, so I don't.
So under E, are we gonna say it's not building, but it's front yard setback?
Right, I think we make this consistent. Will that work? Scott, just take the same language from what we approved in.
Yeah.
7 and use the same language here. So it's front yard setback.
Use Article 7.
Yeah, use the language that we agreed upon in Article 7.
and look at this, setbacks all one word in this, all three of these.
Yeah, they got it right.
Flag lots treated differently as far as side and rear.
Yeah, I think we decided to get rid of not applicable to flag lots in 7. I think we should maybe get rid of them in 8 too.
It's even more of a problem with a 2-acre flag lot. You don't have much building site.
Right.
You know, you're eating up half an acre with your driveway. Then what? You know, if a normal sized house, how much setbacks would you theoretically have? I think we need to be careful not to.
Well, that's why I'm saying that by going ahead, we'll use the same language you said. It'll match here.
I'm not even sure.
I think
Room.
at 7, we went with what, 50 in the front? And I think 25 in the front is not unreasonable. Here. 25 on the side.
Use 25 from instead of using the 50. Yeah, if you use the 50 and the 80. And that's 130 feet out of the lot,
Mhm.
And I'd have to
across.
diagram it and see if there's really room. I mean,
Yeah,
I don't
well,
see that 80
some-
feet.
Some might work and some might not.
Yeah.
And that's where BZA probably comes in.
It hasn't been an issue yet.
Yeah.
That's been raised by the zoning inspector, Scott.
Yeah,
Question to you then, should we in fact reduce the rear setback here from the 80? Been suggested already that we reduce the front to 25 from the 50.
well, that's what it was here. It is listed as 25 here, so, like,
Oh, that's because it says minimum setback 25 feet all the way around, but Article 7 now says 50 feet. From where it widens out.
mhm. I would go with 25 from where.
But here we're
so
saying we'll stick with the 25 feet for the front setback.
I would.
Yeah, I'm not opposed to it. I'm just wanting to make sure. In terms of clarity here.
So then is the rear still, I mean, it's still valid to question whether 80 is too much for the rear.
Yeah, I don't know whether 80 is too much for the rear.
That goes.
On a 50, on a 2-acre lot.
Mhm.
Maybe it should be 50.
Yeah, or even 25.
Yeah,
I think we'll get some feedback from Mike.
50, yeah, 50 ought to work.
Yeah. How about go ahead and change the front to well, as you pull that language from 7, change the 50 to 25. And for the rear yard setback, maybe we should go ahead and reduce that
To 50.
to 50 or 40.
And whatever you make it, I think we'll talk about it.
We'll talk about it with Mike either way. Okay, let's go ahead now and change it to 50. As you make that transfer. Okay, and that takes us to the last page, which doesn't have any frontage.
Hey,
I can make the same landscape reference.
Yeah, yeah. it's just kind of-
Right. All right. Gosh, that's great. Okay. Scott, next time. Plan will be potentially then to go through this again, and any feedback that Mike didn't stay for this discussion. I'd like to get a copy to him so that he could then review it. How quickly could you get that back to us so we can go ahead and tell him to give us some feedback, because we'll plan on taking this up again at our workshop meeting in March.
Couple months.
I'm sorry, in February.
Like a couple weeks.
Yeah, let's see. 2 weeks from now would be basically the 5th, and our workshop meeting would be on the 12th. So yeah, that'd be fine. Okay. Thank you very much. I don't have anything else then.
I move that we adjourn.
second,
Moved and seconded that we adjourn. All in favor? Aye.
Aye.
Aye. Okay, we're adjourned.
Valerie, aye.
And we did adjourn at 9:37, so we ran over 7 minutes.
Let's just say it's 9:30 and not push it.
I just looked at my watch.
but we finished it, so.
Yes, that's good.
Yeah.
I'm going to give this copy with the penciled in changes to Valerie and ask her to go ahead and create a draft for us. I changed the title for the time being, then as a working title, it will be application for change in zoning, paren, not to be used for requesting the use of an overlay district.
Kind of wordy.
Well, I'm following his suggestion of putting that in parentheses.
Okay. Yeah.
Well, we can change it. I'm just saying as a working title.
Mhm.
So anybody's got a better idea? We'll definitely make that change.
I'd like to know what.
If you got one right now that you want to suggest, I'll go ahead and change it before I give it to Val.
I only wrote down application for a zoning amendment, not for overlays. Not for use in overlays.
16-08.
Okay, so change in zoning not to be used for requesting an overlay.
And then there's this one.
That's not almost the same,
Yeah,
same thing that you got. If I'd worded
it's
that.
long.
Not to be used for requesting an overlay.
I don't need to know about.
I got a feeling that it'll be discussed.
Mhm. Yeah. Oh, Tom will want a charter.
I'll try.